Of the LCH. Welcome to this this episode of the LCH Lunch Series on humor in the law. I'll introduce the host for today's session, Alberto Godioli, and he'll then introduce the speakers. And we'll have the Q&A directly after each paper. So we'll have a paper, then 10 minutes of Q&A, then the next, and then the next one after that. Alberto Godioli is Associate Professor of European Culture and Literature at the University of Groningen, Program Director of the Netherlands Research School for Literary Studies. He's Principal Investigator of the research project Humor in Court, funded by the Dutch Research Council, and founder of the Forum for Humor in the Law. I'll put their URL in the chat in just a minute. An international platform for lawyers, humanities scholars, and practitioners focusing on global case law concerning humor and free speech. His work on this topic has been published by Humor, the International Journal of Humor Research, the International Journal for the Semiotics of Law, and the Columbia Global Freedom of Expression series. With Brigitte Adriaansen, Andrew Bricker, and Ted Laros, he edited 2 special issues on humor in the law. One is for the journal Humor in 2022. That issue is titled Humor and the Law, the Difficulty of Judging Jests. The second is for Law, Culture, and Humanities. That will appear in volume 21-2 in about a year, and it's titled Humor in the Law, Laughter as Critique, the Limits of Laughter. Please, Alberto, take it away.
Thank you so much for your very kind introduction, Simon, Professor Stern, and thanks so much for giving us the opportunity to present our double special issue on humor and the law. Hi, everyone, in the meantime. And first of all, I'd like to stress that I'm here today also on behalf of my wonderful co-editors, Andrew Bricker, Brigitte Adriaansen, and Ted Laros, with whom I've had the pleasure of working on both special issues, indeed, for humor and law, culture, and the humanities, respectively. So this was very much a team effort, and I really like to start by acknowledging their invaluable contribution to the special issues. And we are very happy, actually, with both special issues, with both collections, and I think that taken together, they are indeed an organic reflection of the different angles and disciplinary perspectives represented by us as individual editors of the special issues, but also by the authors and contributors when it comes to humor and the law. And in this respect, I would like to briefly open by going back to one of the foundational studies on humor and the law, namely Laura Little's Guilty Pleasures, Comedy and Law in America from 2019, which identified 3 main directions in this then nascent research area. In particular, first of all, law on humor, meaning the analysis of legal cases concerning humorous expression in relation to free speech, hate speech, intellectual property, and so on. So that's law on humor. Secondly, humor about the law, covering the different ways in which humor and satire can be used to respond, comment, or critically reflect on the law. And thirdly, humor in the law, analyzing unexpected occurrences of humor within legal discourse and practices. Now, this, of course, is only an indicative typology, as is also the case with similar distinctions between different trends within law and humanities at large, after all. However, I do think that it's fair to say that our 2 special issues mostly focus on the first 2 directions. In particular, the humor special issue is mostly about law on humor, we can say, as it focuses on legal cases about humor and satire from different historical and geographical contexts. And the law, culture, and the humanities special issue instead is mostly about humor and satire as a response to the law, so humor about the law. Now, the 3 talks that we are going to hear today ideally represent both of those angles and directions in humor and the law. More precisely, we will start with a talk by Dr. Elisa Kriza based on her fascinating article about which you can already see, I think, in the screen sharing here, which is based, the talk is based, as I was saying, on Elisa's article about the trial faced by two satirical authors in the Soviet Union in the 1960s. So very much law on or law against humor in this case. And the other two talks instead deal with humor as a response to the law. In particular, Dr. Jessica Apolloni will discuss the parody of legal proceedings in the first recorded performance of Shakespeare's Comedy of Errors and the mock trial that followed. Dr. Diana Jorza instead will focus on three Spanish comedy films from the 1950s and 60s and their satirical criticism of housing laws in the Franco era. Each talk, as Professor Stern, as Simon already mentioned, will be 15-minute long and will be followed by a 10-minute Q&A. And I will fully introduce each speaker at the start of their respective talk. So for now, I will just copy some more links in the chat for your perusal and then immediately move on to introducing our first speaker. Let's see if I manage to copy paste some links in the chat here. Yeah, you should find them there. I see that some are already there, but what you will find in the chat are basically the links to the special issues, to the articles that will be discussed today, and to the Forum for Humor and the Law, which, as was mentioned in the introduction, is indeed a platform I had the pleasure of founding with Laura Little back in 2022, hosting a growing network of law and humanities scholars. So you are very welcome to visit the website and sign up to our newsletter to find out more about upcoming initiatives on the topic. That being said, I'm very happy now to introduce our first speaker, Dr. Elisa Kriza, who teaches at the University of Bamberg in Germany, where she was awarded her postdoctoral degree or habilitation in 2023 for the upcoming book, The Most Bitter Irony, Satirical Interpretations of State Crimes in the Soviet Union and in 20th Century Mexico. And Elisa's recent publications also include articles on the journals Humor, which we will hear more about soon, and comparative literature studies as well. Elisa, thank you very much for joining. The floor is yours.
Thank you very much for inviting me today, and thank you everyone for joining our talk. I will speak about the trial of Andrei Sinyavsky and Yuli Daniel in Moscow, 1966, and the Soviet limits of humor. After some background information on the trial, I will discuss how the trial defined the limits of humor and how it represented a battle over moral high ground. I will focus on two issues debated during the trial: satirical aggression and its targets, and representing reprehensible views in satire. Yuli Daniel was a translator and a writer, and Andrei Sinyavsky, he was a university lecturer, but also a writer and literary critic. So both of these men published several satirical novels and short stories under pseudonyms in Western countries during the Cold War. They had these works smuggled out of the Soviet Union and published without the permission of the Soviet authorities. In 1965, both men were arrested in Moscow and they were put on trial in February 1966. This trial was immensely important in Soviet history because it was the first time that writers were convicted for the content of their novels and not on unrelated charges. However, because the evidence in the trial consisted in fictional text, the trial shocked the Soviet intelligentsia and it galvanized the development of a human rights movement in the Soviet Union. But the trial also brought up crucial questions that remain relevant today. The clash between the author's view of what satire is intended to do and what the prosecutor, the judge, and the political establishment believed it should do was in some ways unique to the Soviet Union, but in other ways, it represents conflicts that persist today. The Soviet Union had high expectations on the educational value of art, including literature, and it expected art to follow the line of the Communist Party. This may be similar in other authoritarian countries today. However, other aspects of this trial are relevant to the wider world as well. Satire is a literary mode that claims moral high ground while using aggression against the targets of its criticism. The Siniavsky-Daniel trial was the battle over moral high ground that questioned the legitimacy of the author's satirical targets and the moral position of the writers. As in other cases, the Soviet authorities were using this trial as a didactical event to mobilize the population against these writers and people like them. Conflicts over the legitimacy of satirical targets and satirists' moral standpoint are common even in democratic countries. In the age of social media, mobilization against satirists and battles over the moral high ground have become more common, even when they are not orchestrated by state actors or have the same dire consequences as state persecution. This makes this discussion of the Siniavsky-Daniel trial nonetheless more broadly relevant. So Andrei Siniavsky and Yuli Daniel were charged under Article 70 of the Penal Code of the Soviet Russian Federation, which criminalized libel and defamation of the state and agitation and propaganda with the aim of undermining or weakening the state. This law was abused to oppress critics in the Soviet Russian Federation. The use of this law was unusual in this case because the texts were not overtly political, yet the law was equating basically the satirical prose with political pamphlets used in anti-Soviet agitation. In the trial, the discussion of the texts focused less on libel of the state and more on the authorial voice and the legitimacy of the satirical targets. This was a deliberate strategy to cause indignation against the writers. Both writers were found guilty, and Siniavsky was sentenced to 7 years of prison labor and Daniel to 5 years. This trial has touched a lot of points that are very interesting, which I will discuss in just a bit. But what is also interesting is what was not the focus of the trial. And this is worth noting because this reveals obvious political decisions. Even though this was a libel trial, the relationship between social reality and the satirical texts was widely ignored. Historical events discussed in the novels by these writers, such as the killing of priests during the Civil War, mass collaboration in Stalin's purges, and Soviet anti-Semitic persecutions were glossed over. Instead of focusing on these topics that pertain to Soviet power and could therefore be seen either as defamatory or not defamatory according to the law, social problems like alcoholism were brought up repeatedly, but they were dissociated from social reality, as I will later elaborate. These two writers were accused of intending to weaken the state, but their disloyalty was only proved implicitly by questioning their pessimism about the future. Faith in a better future was crucial to Soviet ideology. This meant that pessimism was understood to be a sign of disloyalty. The implicit expectation to be optimistic about the Soviet future was never addressed in the trial, but taken for granted. Because both authors expressed fear of a return of Stalinism, they were deemed disloyal to their country. The only Soviet law that these authors did break was publishing in the West without Soviet approval, yet this was a minor topic during the trial. So in its battle over the moral high ground, the prosecution focused on provoking moral indignation and a sense of victimization of the Russian people. Both the prosecutor and the judge questioned the portrayal of alcoholism in Siniavsky's novels. The judge argued that it is liable to depict negative aspects of Russian life. So during the trial, the judge asked Siniavsky, quote, "Why did you send out this lampoon? This is your people, the Russian people, which has made such sacrifices, which has borne such sacrifices in a terrible war and suffered and forged steel for victory, lost 20 million, but stood firm and has created a great culture. These are you thieves and drunkards, are they? Don't forget that you are being tried by a court of the Russian Federation." End of quote. Siniavsky responded by expressing his admiration for Russian culture, but he admitted that alcoholism definitely is a problem. When the judge reproached that Siniavsky had sent this text to the West, Siniavsky responded sarcastically, quote, "You talk as if they used to think in the West that we were a sober people, but now they found out that we are a lot of drunkards." End of quote. Siniavsky tried to turn the discussion towards social reality as a satirical target. Alcoholism had nothing to do with the accusation of libel against the state, which was what Siniavsky was being tried for. Even if Siniavsky's text was libel against the Russian people, there was no law against it. But the judge and the prosecution insisted on this point. The focus on alcoholism as libel is also surprising because alcoholism was the subject of officially sanctioned satire. For instance, in the satirical magazine Crocodile, which was very popular in the Soviet Union at the time. You can see some examples of their cartoons lampooning alcoholism on the slide. Furthermore, the Soviet government frequently led anti-alcoholism campaigns. But the prosecution returned to the topic of alcoholism repeatedly, always in a tone of moral indignation over the choice of this satirical target. This aspect of the court proceedings was even printed in Soviet newspapers at the time. During the trial, one of the public accusers referred to the text as evidence of a debauched imagination, as she called it, that paints a false picture of life in Siniavsky's depiction of alcoholism. This discussion denied the relationship between Siniavsky's text and a well-known social problem. Focusing on alcoholism was also strategically relevant in mobilizing the population against these writers to divert attention away from Siniavsky's criticism of the state towards this criticism of the population, of the people. So the prosecution sought to create indignation over the alleged maliciousness of Siniavsky's criticism that affected regular people, not just the state or its leaders. It sought to create an image of victimization of the majority population, which is why the judge and the prosecution referred to the Russian people specifically, which was the majority population in the Soviet Union, and made references to World War II and its sacrifices. They decoupled the satirical text from the societal model on which it was based, which was widespread alcoholism, and created the impression that the target of criticism were the virtuous Russian victims of World War II who were being libeled by Siniavsky. Reading the court proceedings, the strategy seems almost comical. The prosecution sought to delegitimize the lampooning of alcohol addicts by claiming that the entire Russian people were the targets of this criticism. Ultimately, the prosecution was in fact equating the Russian people with the alcoholics in Siniavsky's texts. Not even Siniavsky had gone that far. The prosecution interpreted the portrayal of immoral behavior like heavy drinking not only as libel, as described previously, but also as resulting from the author's immorality, which is why I would like to delve into the question of whose opinions are voiced in satire and how it relates to the representation of reprehensible views or behavior in satire. Siniavsky's and Daniel's works comment upon social problems, but more importantly, they reproach abuses of justice in the Stalin era and also the role of violence in the imposition of communism in the USSR. They were written after 1956, when General Secretary of the CPSU, Nikita Khrushchev, had admitted that grave injustices had been committed in the Stalin era. These two writers wished to discuss these issues further. However, because they chose satire as their mode of literature, that meant that they chose to focus on the worst aspects of Soviet reality and to do so in a hyperbolic and grotesque manner, which was obviously not true to history. But this was misconstrued as libel during the trial, but that was not all. The prosecution argued that the negative characters in the novels by these authors represented their own personal views. Therefore, not only were the texts reprehensible, but so too were the authors. The prosecution focused on equating the views of characters and narrators with those of the authors. This way, it tried to represent them as morally corrupt individuals. Andrei Siniavsky and Yuli Dania were both accused of anti-Semitism because in some of their works, there were characters who expressed anti-Semitic views. Siniavsky and Daniel defended this portrayal, pointing to the fact that these were negative characters representing a social problem. But the prosecution insisted that the opinions of these characters should be seen as equal to those of the authors of these texts. The strategy also aimed at defining didactical limits to satire as a form of art. The argument was that by allowing problematic views to be explored in satire, there is a risk of contamination. That means that readers might adopt these problematic views or behavior. This fear grows out of the understanding that satire seeks to evoke empathy and that negative protagonists are unworthy of empathy and a bad example. Although this perspective is closely linked with Soviet views on art in general, it is also widespread in non-authoritarian countries where some people fear the spread of moral corruption through its depiction in art. For instance, not only authoritarian countries such as the Soviet Union or today's Russia see the use of profanity and humor or other forms of cultural output as potentially causing moral decay. The difference is how the state reacts to these purported fears of contamination. So coming to a close, the outcome of the trial was no laughing matter. Siniavsky was sentenced to 7 years in a prison labor camp, and Daniel to 5 years. Here on the slide, you can see a picture of both writers with their wives and friends before they were arrested. After serving his sentence, Siniavsky was forced into exile, and Daniel was not allowed to work as a writer or translator after his release. Yuli Daniel died in Moscow in 1988. His son, Alexander, co-founded the human rights organization Memorial. Andrei Siniavsky died in exile in France in 1997. His son, Yegor Gran, works for the French satirical magazine Charlie Hebdo. The Siniavsky-Daniel trial is part of these writers' legacy, which includes the defense of the freedom to criticize one's own country and one's own society using satire and humor. The trial was historically relevant because it equated satirical fiction with political speech. The trial delineated the limits of humor and satire beyond political criticism. Even the most common social problems were off limits when the authors did not unambiguously demonstrate a loyalty to the party line. Thirdly, ambiguity, irony, sarcasm, pessimism, and offensive humor were deemed contrary to the educational purpose of Soviet satire, and this posed severe limitation to writers' creativity. However, the trial backfired by drawing worldwide attention to these writers' work, and the Western market for Soviet dissident literature in general skyrocketed. So whatever chilling effect this trial had in writers' work within the Soviet Union after the trial, more Soviet writers published illegally in the West than ever before. So this trial epitomizes hostile reactions towards satire that continue to exist. The aversion towards ambiguity, conflicts over satirical targets, and battles over moral high ground as decoys to silence critics. And if you would like to learn more about this, here is a link to my article published in the special issue on humor and the law. Thank you very much.
Thank you. Thank you so much, Elisa, for this wonderful talk. I am looking for the applause emoji here. Okay, found it. So
thank you.
We go completely multimodal here. Thank you so much. We have roughly 10 minutes for the Q&A. Given time limits, I would invite everyone to be as concise as possible in both the Qs and the As, of course. If you have a question, you're very welcome to type it in the chat or raise your hand so that we can open your mic. I will give you a few seconds also to type in or raise your hand if you are still thinking about the question, but I see, Simon, you raise your hand.
Yeah, I'll just try a quick question. So obviously this raises so many issues that I expect will run throughout today's forum, but a most obvious one has to do with the difficulty the courts generally have in grappling with irony, humor, satire, ambiguity. So I'll just offer a parallel context having to do with free and direct discourse in fiction. So here's another area where courts have difficulty figuring out, does free and direct discourse recruit the reader, align the reader, express directly the writer's views or not? I might put in a link, a recent article that addresses this. But I was just wondering if you might comment on that obviously very complicated and rich aspect of it.
Yes, thank you very much. And that is a very important point. And I think that this, because this wasn't a trial in an authoritarian country, every time that the authors or their defense tried to point towards this issue of the complexity of having different authorial voices, this discussion was quashed. But importantly, there were cases in their work where it was much more difficult to understand whose voice is the authorial voice, the implicit authorial voice, because there are so, especially in Siniavsky's work, Lubim, of the Makepeace experiment, there are so many, it's a mise en abîme, so there are so many different narrators and so many different perspectives that it can get very complicated. However, in other cases that were discussed in the trial, it was much more straightforward that these were actually negative characters. For instance, in The Trial Begins, that discusses the doctor's plot, which is an anti-Semitic persecution started by Stalin and the leadership in the Soviet Union. So instead of discussing the actual problem, which was this campaign, they focused on saying, oh, because there's anti-Semitism in the text, then Siniavsky's anti-Semitic, which is obviously a very ridiculous interpretation. But it was because obviously the Soviet Union was an authoritarian state trying to bring a conviction no matter what. But as you say, it can be difficult, and it was difficult in some of these texts, but in other texts, it was more straightforward. Mm-hmm.
Thank you. Thank you so much for both the question and the answer. I see a couple of questions in the chat, but also a raised hand. I will start by reading one of the questions in the chat, and then we go back to Nicole, I think, for the live question. So I will read Naomi's question from the chat. Wonderful. Thank you, Elisa. To begin with, wasn't the judge right that satire functioned as political critique? And isn't political critique often a core part of satire? For example, Orwell and so on and so forth. Yeah.
Mm-hmm. Yes. Well, the point here is not only that obviously some of the criticism was political, but the law that they used to prosecute them was exactly the same law that was used for straightforwardly political agitation, and that was, I think, what was new in this case, that they equated fiction with agitation. So yes, so it's not only that it had political implicit, but political context, but it was used as if it were explicit.
Thank you. Thank you so much. I think we still have time for a couple of questions, beginning with Nicole, indeed.
Thanks so much, Elisa, for this rich talk. You put so much into 15 minutes. So I'm wondering, I'm thinking back to cases like, Ngugi wa Thiong'o in Nigeria, or more recently, Kakwenza Rukuribashaija in Ukraine, and how Western authors wrote to support them and offer comparative context of defining satire. Did that happen in this case? Thanks.
Thank you. Well, there was an incredible way of solidarity with these writers. And even among Western communists, a lot of people, they decried what the Soviet state was doing with these writers. So in that case, there was a lot of support, and even Soviet writers that were members of the Soviet Writers Union penned a letter of support towards this writer, saying that there should be a difference between fiction and non-fiction when discussing, the political aim of a text. Yeah, I hope that gives you some context. Mm-hmm.
Thanks for these very efficient and concise answers as well. I see, well, I have questions both in the chat and live, but I think that Jonathan already started asking a question, so please go ahead, and then I will read the question from Brigitte in the chat.
Thanks, Alberto. I'm so sorry to be late. I thought it was at 12 o'clock. I mean, that's silly of me. Anyway, great. What I heard, really happy to have heard it. I guess, and you maybe said this at the beginning, but we have to keep in mind that the end of the trial, the outcome of the trial, was foregone conclusion. Right? I mean, that this was a political institution, not an independent judiciary, and the judges kind of knew, I don't know all the details, but knew almost certainly what the Politburo wanted them to find. And that's something I guess we always have to keep in mind when we're talking about Soviet law.
Yes, absolutely. Yes, indeed, that was at the beginning of the trial, not at the beginning of the trial, at the beginning of my talk. I mentioned that this was absolutely a show trial, basically. So yes, the outcome, or the guilty verdict was already known, basically, to the judge and the prosecution. And also, for instance, they made sure that the people who were allowed into the courtroom were basically hecklers. Except for the wives of the authors, nobody else, like none of their supporters, were allowed into the courtroom. So it was really a show trial in that sense as well. But I think that what is interesting for us today, I mean, obviously the Soviet Union was an authoritarian state, so it was an unfair trial. But I think that the types of discussions and the types of arguments that they decided to make and the strategies they took, we confront this in authoritarian countries today as well. And I mean, for instance, I've observed it in the case of Turkey, for instance, where insults towards the president are often, in a narrative where they are construed as insults to the Turkish people, So, and in the same way that here in this trial, the court tried to make it appear as if, the entire Russian people were being insulted and not the Soviet authorities or concrete, forms of misbehavior. Mm-hmm. Thank you.
And on a similar comparative note, I will read the question from Brigitte from the chat. I was curious about how these battles over moral high ground resonate in Mexico. As I understood, you are preparing a monograph on this topic. I was curious about the connection you make between Russia and Mexico and why you take these two cases in your more recent work.
Yes, thank you very much. Well, in this case, I mean, my book is about the way that state crimes are discussed in satire in both countries. But when it comes to freedom of speech, there was a great difference between 20th century Mexico and 20th century Russia. So in that sense, the battles over moral high ground were very different because less was at stake. So because of the type of persecution that Soviet writers were up against, it was a very, very different situation. However, the thing is that the Mexican government basically believed that nobody reads literature, so they left literature more or less alone when it comes to censorship. What was censored was the press, so news media of all kind, also television. But when it comes to literature, there was there were very few works which were censored, and that was because the government basically felt literature doesn't really matter. It doesn't have any meaning for society. And that was completely different in the Soviet Union. So the Soviet Union wanted to control and use literature for propaganda purposes. So in that sense, when it comes to this particular question, there was a very different attitude and very different types of battles going on. But thank you very much for this question.
Thank you. Thank you so much, Elisa. And thanks everyone for this very informative and insightful Q&A as well.
Thank you.
On top of the talk itself, which indeed was a lot of food for thought. For the sake of timing, I will now happily move on to introducing our second speaker, Dr. Jessica Apolloni, who is an associate professor of English at Christopher Newport University. Jessica specializes in comparative law and literature in the early modern period and has received grants from Fulbright and the Mellon Foundation for her current book project, Violent Ends, Shakespeare and Comparative Law. Her scholarship and reviews have appeared most recently or are forthcoming from Law, Culture and the Humanities, Renaissance Quarterly, and Shakespeare Studies, among others. Jessica, great to have you here. Over to you.
All right, thank you. And yes, let me know if you can't hear me or if the slides aren't working, anything like that.
Yes, everything is working. Thank you.
Okay, thank you. So yes, thank you to the editors of this special edition and to the organizers of this session today. Given the range of topics, just before hopping on Zoom, I realized explaining in a quick way what where the context is of my talk. I'm actually going to take my title like backwards. So it's a night of errors, chaos, comedy, and comparative law at the Inns of Court. Well, the Inns of Court, this is why we're going to go backwards through the title. The Inns of Court are early modern sites of legal training and legal learning. They're residential sites. I have some pictures that I'll show you in just a minute that were really crucial for the study and development of English common law in the Renaissance or early modern time period. The comedy and comparative law part of it is there's been a really great wealth of new research on law and literature that occurs at the Inns of Court, in that a lot of the people studying to be lawyers become playwrights, like John Webster and John Marston, and vice versa. A lot of the kind of legal and literary training is happening at the same time. But I'm interested in this from a more comparative perspective of comparative classical ideas, Italian ideas that are circulating, so that we can see how literature is this kind of vehicle for authors to transnationally kind of understand different things going on in their specific kind of legal system, especially in this time period, as like I said, the common law is professionalizing and developing. And then the last part of the title here, so actually the first part, but the last part I'm explaining is the spicy part, and what I'm going to especially talk about today, a night of errors and chaos. So the Inns of Court also had these festivals that would happen, and they would occur for a few weeks up to a couple months during the Christmas time holidays. And these revels actually operated like artificial city-states. They would appoint, a prince. There'd be a parliament. People would have, different kinds of positions they get appointed, and they would do different, diplomatic things. So it's all this kind of staging of mockery or staging of, statecraft, because the Inns of Court, some people wanted to become lawyers, but other people were vying for positions at court and governmental officials as well. So Shakespeare's first known performance of Comedy of Errors created this Night of Errors, in which Shakespeare was put on this kind of mock trial that happened the next day afterwards. So that's what I'm especially going to talk about, because I think it's more relevant, or especially relevant, to satire and the kind of themes of our presenters today. And let's see, moving along here. Here we are. So the Gray's Inn Christmas Revels of 1594 to 5 narrated an anonymous text from 1688 called the Gesta Grayorum, which you have a copy of in front of you on the slide, included the first recorded performance of Shakespeare's The Comedy of Errors. Revels at the inns were intricate affairs parodying government rule, including a fictional coronation, parliament, plays, and mock trials. On December 28th, 1594, the Gesta Grayorum claimed Shakespeare's play created a night of errors that led to a lengthy mock trial the next day. In the article for Law, Culture, and the Humanities that I wrote for the special edition, I analyzed the commerce of legal ideas occurring between Shakespeare's play, its source in Plautus's Menachmi, and the ensuing commentary from the mock trial in order to show how key generic elements of Roman comedy became central to legal training at the inns. So I do have just a quick slide to show you what the Inns of Court more or less kind of look like, a couple pictures there. And I'm just going to highlight a couple things that I mentioned in the article before getting to the trial to make sure the kind of genre elements I'm interested in are clear as we get to the mock trial as well. So I'm actually going to switch slides already to get to Shakespeare's source for his play in Plautus here. So I have a quick summary, and mostly it's because Shakespeare's play and Plautus's source, they're very similar. So in the classical Roman play Menachmi, Plautus illustrates the comic possibilities of mistaken identities, error, and confusion. The play focuses on a set of identical twins separated when they were young until Menachmus the traveler of Syracuse appears in Epidamnus, the home of the other twin, Menachmus the citizen. As the play progresses, family members of Menachmus the citizen, as well as the larger community in Epidamnus, confuse the two twins, leading to the citizen being locked out of his own house and a doctor pronouncing him mad. The twins eventually meet each other and resolve the confusion and misunderstanding. Themes of social identity, authority, and community in Plautus intrigued many authors in the pre-modern period, including Shakespeare. Building from the evolving genre conventions of comedy, Shakespeare closely adapts Plautus's plot in The Comedy of Errors. Yet Shakespeare doubles the set of twins so that each brother also has a slave. Dromio is the character's name. So there's two sets of twins that are getting confused for each other constantly, and makes changes that emphasize socio-legal dynamics in Plautus, such as the performance of law in a community. In the article for the special issue, I particularly examined comparative Roman materials and legal training at the Inns of Court that stress these connections between law, social relationships, and performance. The first section discusses the development of comedic genre conventions within the legal environment of the Inns of Court, where comparative literary and legal ideas widely circulated and developed. I then turned to two key genre features of comedy, doubling or kind of twinning, like the twins, the twin characters, and error or mistaking, right, one for the other, to explain how the comedy of errors critiques the performative power of legal authority in a community. While many scenes in Shakespeare's play mock legal officials, the ensuing mock trial at the inns further highlights the performance of law at the heart of interpretive processes and procedures. So before I get to the mock trial, I mostly wanted to show you just three kind of quick quotes that represent three of the key ideas that I've been interested in with this project. The first that's on our slide here is from Andrew Zerker, who argues like understanding the play, you have to almost understand this play within the mock trial context and the Inns of Court context that's going on as well. And the quote I have on there is that this invites us to ponder and adjudicate upon the importance of the connection between causes, errors, and ends, between literature, interpretation, and law. So error as a main genre feature of comedy, right, that people are making mistakes is such a key element of Roman comedy, but then as it gets adapted into even Italian comedy and then Renaissance, comedy like Shakespeare's play that we're looking at today. And multiple connotations of error, like the legal error is what I'm most interested in and what Zerker talks about in that quote. But the comedy of errors has like religious connotations of error, philosophical connotations of error. So I've become more and more interested in error than I ever thought that I would. The second quote talks about the genre kind of line that we can look at leading back to Plautus. So this is from Robert S. Maiola, who claims the monarchy especially bequeathed to following generations a prototypal processo turbarum, which playwrights adapted to raise laughter as well as searching questions about identity and the nature of the self. So I was interested in the error, right, kind of genre convention, but as it especially is looking at the social aspects of law and performance. And the last one that's on here is also still kind of about error, but it's from Douglas Lanier. And I recently heard someone talk about comedy of errors that the errors are close to terrors. And this quote, I think, speaks to this as well, of like this loss of identity or the real stakes of having confusion that end up in the play, but then also in the mock trial, which I'll quickly discuss here. So Douglas Lanier talks about this, the kind of mixing up of one twin for the other that constantly happens in the play. With this quote, how might identity be disrupted when the public marks of that identity are not merely counterfeited, but exactly duplicated and possessed by someone else? Once doubled, those marks become nightmarishly iterable, physically the same, but signifying differently, open to a wild variety of preposterous supposes, and ultimately leading to near social breakdown. So those are just a couple things to talk about error as a genre convention happening in the play. But as I mentioned, for today, I really wanted to talk about the mock trial because it doesn't get as much scholarly, well, it's gotten more recent scholarly attention, but it's just a fascinating kind of moment of our playwright kind of being put on this mock trial event. So the classical concepts of error and doubling extend from the fiction of Shakespeare's play into the Gray's Inn revels. The staging of this play was designed for entertainment for the ambassador of the Inner Temple and their contingent as the honored guests of the night. However, quote, when the ambassador was placed as aforesaid, and that there was something to be performed for the delight of the beholders, there arose such a disordered tumult and crowd upon the stage that there was no opportunity to effect that which was intended. The Gesta Graeorum, which I have on our slide here, explains that the large crowd gathered for an evening of entertainment would not make room for the professional actors. Worse still, a quote, when the prince and his officers had in vain a good while expected and endeavored a reformation, the length there was no hope of redress for that present. The chaotic scene prompted the contingent from the Inner Temple to leave, quote, discontented and displeased. And finally, and this is towards the end of the section I have on the slide here too, A comedy of errors, like to Plautus his Monachmus, was played by the players. The account summarizes the evening as such, so that night was begun and continued to the end in nothing but confusion and errors, whereupon it was ever afterwards called the Night of Errors. So this evening of errors, according to the Gesta Graeorum, greatly injures the reputation of Gray's Inn as a discouragement and disparagement to their fictitious state and their recently crowned Prince of Purple. On the following day, the prince directs an inquiry into the cause of this disorder and disparagement. Here, the account starts to connect the previous errors to supernatural forces, stating the cause was, quote, especially by sorceries and enchantments, and namely of a great witchcraft used the night before. The author goes on to detail the lengthy mock trial against a, quote, sorcerer or conjurer that was supposed to be the cause of that confused inconvenience. Presumably, this conjurer is Shakespeare, the playwright, but in any case, using this specific term has interesting connections. For example, Lorna Hudson mentions that the term conjure and conjurer occurs 6 times in Comedy of Errors, more than in any other play. And more specifically to the point on law and performance, Hudson includes a note to Greenblatt's scholarship that portrays Shakespeare as a Renaissance conjurer. In this case, the term meant someone who has the power to call forth or make contact through language with things, voices, bodies, spirits that are absent. By using the word conjurer, the Gesta Graeorum already ties the Night of Errors and subsequent legal proceeding to the realm of performance. Remarkably, the prisoner, right, our Shakespeare, we presume Shakespeare, but our prisoner, as it's called in the text, turns this call of conjuring onto the proceedings itself. During the mock trial, the prisoner discloses, quote, all the knavery and juggling of the attorney and solicitor, which had brought all this law stuff on purpose to blind the eyes of his excellency and all the honorable court there, going about to make them think that those things which they all saw and perceived sensibly to be in very deed done and actually performed were nothing else but vain illusions, fancies, dreams, and enchantments. The prisoner uses the same exact accusation of enchantment, equating the legal proceeding with legal conjuring, or the law's own ability to create theatrical illusion. The behavior and actions of officers then become a supporting evidence of the prisoner's claim, including a reminder that the prince and his officers were unable to contain the disorder from the Night of Errors to begin with. While the prisoner clearly critiques the overall performance of the mock legal officials, this interesting connection between legal conjuring and fiction making is made even more evident in a parallel scene from the Comedy of Errors. The prisoner's clever response, turning accusations of conjuring against the mock court assembled, directly parallels Antipholus, it's a character, one of the twins in Comedy of Errors, Antipholus's denouncement of the conjurer, Dr. Pinch. And so I found this recent slides of student production, but I feel like they did such a great job of showing Dr. Pinch as this con artist character, which is exactly, what he operates as in Comedy of Errors. So I have the quote and I'll just read it really fast here from the play itself. So they brought one Pinch, a hungry, lean-faced villain, a mere anatomy, a mountebank, a threadbare juggler, and a fortune teller, a needy, hollow-eyed, sharp-looking wretch, a living dead man, this pernicious slave, forsooth took on him as a conjurer, and gazing in mine eyes, feeling my pulse, and with no face as 'twere outfacing me, cries out I was possessed. Then altogether they fell upon me, bound me, bore me thence. So in the same way, Antipholus critiques the feigned performative authority of Pinch, this con artist character, the prisoner in Gesta Graeorum is critical of the mock trial performance, and this paints the proceedings in the same light as the con man Pinch. Scholars like Virginia Lee Strain have noted that this, quote, opens up the fictional royal court to extensive criticism, as their errors in performance or administration of law are put to scrutiny. While the prince is offended by the prisoner's claims, they are apparently convincing, and by the end of the trial, everyone except our prisoner, or defendant, is charged with types of misconduct in their official roles. The larger erring of the court's legal performance is uniquely represented and criticized throughout the mock trial. So classical error can accordingly be applied to the Gesta Graeorum as a lens for understanding the performance of authority in the late 16th century. The connection between conjuring as a deceptive power in storytelling or illusion and legal conjurations with the feigned authority of Dr. Pinch equate the performance of law with similar deception. while Lorna Hudson's chapter on the comedy of errors in her book, The Invention of Suspicion, details a general legal uncertainty within this play. Most notably, she's talking about in the way evidence can be faked. There's this anxiety about how evidence could be not real or counterfeit. Here, we also see the deceptive power of legal performance. It is consequently not surprising that Martin van Elk has cleverly linked the comedy of errors to the con artist tales of coney-catching pamphlets within this connection of social performance. This critical viewpoint of law and performance also relates back to historical contexts of English subjects' double obligation in the law, where the efficacy of legal performance speaks to the increasing tensions in professionalizing the common law. So this is something I explained in the earlier section where I'm equating doubling or twinning happening with this double obligation, which is noted by Penelope Gung, who I saw as a participant here today. This is great. And Penelope explains that this double obligation placed on subjects in this time period, like to both be magistrates and to obey magistrates, became a source of increased contradiction. So I showcase how the Comedy of Errors, as a play full of contradictions, is a useful space to connect Gung's approach to an overall understanding of how authority is socially constructed and performed in communities. A key part of this professionalization is the social performance of officials, and this is perhaps the most significant legal pedagogical aim of these revels, where scholars have noted the revels' connections to the social status of INS members and increasing social mobility of legal professionals. The revels highlight the importance of legal performance in this changing social landscape. When utilizing this comparative literary perspective, the Gray's Inn revels illustrate connections between law, social roles, and performance, connections that became increasingly significant to the development of the English common law system. And so on my very final slide here in kind of conclusion, is these are the questions I was interested in, with this project. And I mean, I'm focusing on the mock trial for today, but throughout my description or my analysis of Plautus, the source, and Shakespeare, and this mock trial, these kind of key questions of how should the law be performed in a community, how is law tied to social relationships and identities, and how should power be balanced between communal and governmental or central forces. So I will leave it there for our Q&A here. Thank you.
Thank you. Thank you so much, Jessica, for this wonderful talk. I will open the floor for questions right away. I see that Melissa raised a hand to begin with.
Okay, great. It did work. I actually had just a couple. Thank you so much. This is absolutely fantastic, Jessica. I can't see you at the moment, but I assume you're still out there.
Yeah.
So I have just a couple. Oh, there you are. Quick clarification questions. So it might be appropriate that I go first. Build up to some of the more interesting questions. I was wondering if you could say a little bit more about the type of errors, the legal dimensions of the errors in the play. It's been a while since I read it, and I was intrigued by that reference that you started out to Zerker's opening, noting actions. And then also, I think I may have missed, I was just curious if you could clarify what the mock trial was, who was specifically on trial in this mock trial? Was it the play? Was it so the disruption caused by the evening before? But thank you again.
Yeah, absolutely. Happy to explain everything. So errors, they occur in multiple levels actually throughout the play. I mean, on a basic level, it's mistaking like one person for the other, the twins, right? They're always getting mistaken for each other. But I know Lorna Hudson's chapter especially is talking about how like materials that get used for evidence. So at one point there's this gold chain that one of the twins had commissioned from a merchant, but the other twin gets it. And now this is all a part of, this twin gets in trouble because of this, mistake that happens of like, well, this gold chain that's now with this person instead of this person. So I know Lorna Hudson's really interested in like how even material objects can just get misunderstood or mistaken, right, as evidence. And even to go to Dr. Pinch, our kind of con artist that ends up at the end, he's this character they call in once one of the twins, the one who lives there, who's especially getting confused all the time with his other twin, the visiting twin, that they bring this Dr. Pinch to like call him to diagnose him as being mad. And then, that's even being kind of like an exorcist and all of these things. So just to say, even those errors, I kind of think about it as not just these kind of material things, but even errors in kind of like legal performance, right? As being a kind of, it can be anyway, a very misleading or kind of deceptive, right, performance as well. And then in terms of what's on trial, it's a good question. So the trial happens of like, because they were going to stage this play, right, for the rebels, and they have an ambassador from their another inn who's supposed to be there as their honored guest, right? But then there's just like disaster that occurs, like there's too many people on the stage, and there's the quote that I ended up putting in the slide talks about how there's gentlewomen dancing, and there's too much, right, kind of chaos going on. So they're not able to actually like, you know, perform the play they were intending to do. And so that contingent leaves all upset, right, about having to leave. And then, you know, they do a comedy of errors instead. It's kind of this makeshift, quick kind of, you know, what's the word, substitution that I'm thinking of. So then they put the person who's in charge of the play of the entertainments on trial, which scholars all presume is Shakespeare, since it's the comedy of errors, but doesn't specifically say that Shakespeare gets put on trial. But it is the playwright or the person who organized the entertainments who gets on trial. Yeah.
Thank you.
Yeah.
Thank you. And I'm reading now a question from Patrick from the chat. I'm struck by the intersection of troubled and doubled identity in the Comedy of Errors and the fact that the inns were training programs for young men ostensibly seeking to assume a new and adult identity as members of a learned profession. Do you think there are ways in which the performance of the mock trial was something that let the students at Gray's Inn navigate the tension?
Yeah, it's a really great question. Yeah, and I agree that the point it raises, you mentioned fascinating questions about law of evidence, identity, and fraud. I know I've been actually still thinking about, since our first talk, from Elisa's talk, about whose views are voiced in satire. And I was thinking about in relation to this mock trial of like, is it the playwright or like, you know, Shakespeare's views that get voiced in this kind of critical perception of performance? Is it the lawyers, right? The kind of the law students or insmen who are there, you know, and their kind of views? Because I will say there's only, it's actually Andrew Zerker, somebody that I quoted, claims that this actually could all just be by design, so that like the innsmen actually wanted there to be this disorder, and then they do this very like fancy ceremony to get back together with their contingent, the other inns group, you know, to show like we had disorder, but now we can come back together. We're so diplomatic and everything. And so I agree that like it's hard to say. There's so many levels of performance that happen at these inns of court, that there are those just increasing contradictions. And it is why I put Julie Stone Peters' book that came out like right after this article, you know, was submitted and done. But her Law as Performance, I was reviewing that again just before our talk, and you know, the critique, she puts it so perfectly, really quickly. I'll mention it, of that the critique that ends up happening of our prisoner who puts everything kind of back onto the mock trial, right? It says that is, when you watch these law sports, you may think you are seeing only theater, but the rebels, with all their theatrics, illusionisms, and cruel jokes, show law as it really is. This is how law is actually performed. This is as real as law gets. And so I'm similarly thinking about it. Is all I'm trying to say, Patrick, that I think it is something they're using to navigate those contradictions, but those contradictions are still there for sure.
Thank you. Thank you very much. Yeah. Any further questions? I see Penelope maybe raise a hand, but yeah. Please, Penelope.
Hi. I was trying to use my digital hand, but it's easier this way. Thank you so much, Jessica, for this wonderful talk. I've read your article, and I just really enjoy thinking about the continuation of your thesis and argument. I have just like kind of a nerdy question about the publication of the Gesta Graiorum, and I'm wondering if so the Gesta was published in 1688, I think.
Yeah.
And the Night of Errors occurred in 1595, right?
Yeah. Yeah.
So do you have any sense of like why 1688? Who published it? You know, my understanding is that during the English Civil War, like the Inns of Court, they all kind of went into a decline, including Gray's Inn. So do you think like that very late publication of 1688, it is somehow an attempt on the part of Gray's Inn, or perhaps of the wider, Inns of Court, to I don't know, to kind of recover the glory of the past when Shakespeare graced the Great Hall of Gray's Inn or something like that. Yeah, I'm just curious about the belatedness of that publication.
Yeah, I have also wondered about that, and I've spent a decent amount of time researching it. It does seem like people are not 100% sure, right? Like, why is there this delay? Who actually published it? It's presumed that it's off of an earlier manuscript edition of the Inns, like from a witness who was there. But I agree, and the thing I've also run across is what you had mentioned, actually, of your hunch of that the Inns had become kind of less prominent, less important, right? Kind of from a kind of cultural, but also kind of governmental, right, standpoint of people looking for kind of vying up social positions, and that this was a way to try to, again, capture that kind of attention. But it is something that so far I haven't been able, to find exactly an answer of like why 1688, why so much later that it gets published. Yeah.
Thank you very much. I also have a question myself, but in my capacity as timekeeper, I think it's time for me to move on to the third speaker. Maybe I will write my question in the chat, or there will be a way to go back to that during the final wrap up. So thank you so much once again, Jessica and everyone, for your questions and answers. I'll add another digital applause here. And I am now happy to introduce our third speaker, Dr. Diana Jorza, who is an assistant professor of Spanish at St. Mary's College in Notre Dame. She received her doctoral degree from Princeton University and specializes in modern and contemporary Spanish culture, focusing especially on film, humor, comedy, and intellectual history. Diana is currently working on a book manuscript on Spanish film comedy during the first decades of Franco's regime, and she also authored several articles on law and humor, utopia, melodrama, religious cinema, and neorealism, among other topics. Diana, thank you very much for being here. The floor is yours.
Thank you, and thank you very much for the invitation. Thank you very much to the organizer and to all those who made this volume possible. It was one of my most exciting articles to work on, and I probably had never read so much housing legislation before. My article, I don't know if can you see it online? Yes. Okay. So maybe I should go to my actual view. It's called Through a Comedic Glass, Darkly, Ethics, Humors, and Home Ownership in Spain's Early Technocratic Years. So as a time frame, it focuses on the second part of Franco's dictatorship, right-wing dictatorship. And this is past the years of hunger, as the first autarkic part of the regime was called, right after the Civil War, after the isolationists that the regime had to go through. So what happens in the late 1950s when these comedies that I'm focusing on appear? We have a new revamped Spain, very different from the one we had in the early 40s, especially, with a significant economic growth and modernization that follows, especially, and this year is very important, 1957, the switch to a technocratic government, the Opus Dei technocratic government, also because of international pressures and because of all sorts of domestic social protests. We have a lot of economic measures. I won't focus too much on them, but basically what happens, there is a move towards liberalization, which ensures a certain market stability and macroeconomic growth. And with this modernization and macroeconomic growth, especially through advertising and state propaganda, we have a lot of promises of consumer capitalism, prosperity, social advancement. And this happens or contributes, I should say, to the national consolidation and also to the international recognition of the regime, which is no longer isolated as a dubious right-wing fascist dictatorship as it was after the end of the Second World War. However, all these reforms come at a harsh social cost, and they come with a lot of socioeconomic inequalities. And another important phenomenon at this time that very clearly contributes to the housing shortage of the time is the extraordinary migration from rural region to big cities on the one hand, and from rural cities, rural parts especially, but also from cities to various Western European countries. In this major in this context of major housing shortage, the Ministry of Housing is actually created as part of the new government, and it is led not by a technocrat, but by a phalangist. So they were responsible for the right-wing ideological closing of the regime, and he shared the paternalist state intervention stance, which very clearly went against the technocratic belief in a deregulated free market. This led, of course, to many government frictions. The finance minister was a technocrat. He did not believe in a paternalist state intervention, which led to a meager budget for housing. What happened, so at this time when the Ministry of Housing was creating, in Madrid, they were short of 1,200,000 apartments, and a third of the population was living in slum areas at the outskirts of the town, with an average of 9 persons or 2 families per shanties, which of course created, especially in a dictatorship, a fear of political unrest and also pleasant memories of the Civil War and proletarian uprising. So a phalangist plan of social urgency is created that is meant to take care of the state-subsidized housing, but it doesn't work so well in practice because of technocratic budget cuts, all sorts of private interest and real estate speculation, not to mention corruption and inefficiency, and I won't enter into details about that. However, given this lack of private interest in housing building, the only real guarantor of housing remains the state through subsidies, so all sorts of subsidies and incentives, which was meant also to instill gratitude and domestic peace by making the especially the young couples, grateful to the authoritarian state for being able to potentially acquire housing. And what we notice actually at this time, and especially at the end of the 1950s, there is a very serious discrepancy between state propaganda, boasting of modernization, prosperity, efficiency, housing for everybody, and the actual scarcity, the reality of the scarcity of housing and of the shoddy condition of the meager infrastructure. And it's right here in this gap, so to speak, that we have a thriving use of humor. And I think we should think here about what has been said many times about humor's double incongruity. Incongruity in respect to social cultural norms on the one hand and to aesthetic norms on the other. So as a genre, it actually is considered to be characterized by a lack of decorum. And humor and comedies here are by default not to be taken seriously, which can be self-defensive in dictatorships, although the same dictatorships do take humor very seriously, as we saw the case of the Soviet Union as well. And it harbors a very serious suspicion towards humor and towards comedies because of its potential relativizing and distance in respect to power, and also because humor is meant to be shared. You are meant to laugh together with somebody else, especially in the case of film comedies, you are meant to laugh as an audience. So that shared collective public awareness is something that the dictatorship fear. And just as a side remark, which is very relevant in this case, cinema was actually the most strictly censored the most seriously censored of all other cultural activities, and the least censored was poetry, because it was very clearly understood that not many people read poetry, but a lot of people go to the cinema. And actually, it was cinema, both cinema in the forms of cinema in the forms of comedy and melodrama, was the fundamental leisure activity in Spain until the mid-1960s, which ensured its mass appeal and which made the theaters into potential collective spaces of shared critical awareness and dissent. What we also have to bear in mind in a dictatorship is the so-called paranoid hermeneutics. There is always in the spectators an awareness of censorship, of the fact that they might be seeing something, they're never seeing all. There is a pre-given double entendre. So because of all this, and because of comedy's fundamental incongruity, it is in a privileged condition, I think, to make social, cultural, and political incongruities visible, to give voice to the ordinary voiceless individuals in their plight with conflicting regulations, despotic, incompetent institutions. In the case of the comedies that I'm analyzing, the protagonists are all lower middle-class young couples looking for housing. And having a house, especially owning an apartment, was considered a staple of middle class and of a better socioeconomic status. And in all comedies, in one way or another, we see how they gradually abandon their moral principles and personal freedom for for not such a high price after all. The first comedy that I'm focusing on is called La Vida por Delante, Life Ahead. It is from 1958. And according to a review, in this comedy, things don't work at all or don't work well. So the comedy focuses on the very great discrepancy between the propaganda of the time, the political propaganda of the time about housing, and the shoddy reality of state-subsidized housing that are cheap, cramped, and everything is malfunctioning and disintegrating. When you try to open the doorknob remains in your hand. You have a better chance of talking to your neighbor through the very thin ceiling than through the telephone that is not working. And you cannot, the space is so cramped that the young couple together with their parents cannot all fit in the apartment at the same time. This was meant to be, especially as a satire of one of the 1954 Law of Limited Income Housing and of its regulations, which was meant to glorify the state's intervention, for instance, fiscal incentives in helping newlyweds, especially and young couples, to acquire an apartment, a state-subsidized apartment. The reality, however, was very different from that glamorous propaganda. And sometimes these houses were even missing the very basic infrastructure. I'm not going to get into that now, but I wanted to say that although, and this is especially true of the other dark comedies, although they all have a subversive political humor, they also have a very reactionary, sexist take on gender roles. So they might be considered subversive from one point of view, but they are deeply reactionary insofar as gender roles are concerned. Okay, so the other movie I'm focusing on is a dark comedy from 1959, El Pisito del Department, that was actually directed by an Italian director working in Spain, Marco Ferreri. Even if in one way or another, all these comedies deal with how the end, owning an apartment, justifies the means. Here, the point of departure is way more preposterous, because we have a 30-year-old young man who decides to get married to an 80-year-old lady just to inherit as a spouse, to inherit her rent control apartment and grow from the status of subletter to the status of tenant. And this was actually based, however ludicrous it appears, it was actually based on a 1956 story of a marriage just before death, because there was a law that said the surviving spouse inherits the rental, regardless of the time that the two are living together. And what is also peculiarly dark humorous here is that the person who convinces the young man to take this step, and you have an actual image of the wedding right here on the screen in the black and white picture. I don't know if you see, the young man is the one who is marked in the middle, and the lady, the bride, the glowing bride, is at his left side, and it's an octogenarian that lives 2 more years after their marriage. So getting back, what was equally preposterous is that the one who convinced the young man to take this step was his girlfriend, who wanted to make sure that they live in a decent apartment. They had been unable to get married for 12 years because they did not have any kind of housing. So they eventually get married after 14 years due to this. Okay, what is peculiar of this? What kind of humor is peculiar of this? Of these comedies, and of the last that I'm going to touch upon very briefly, is the fact that as dark, they both have a very dark humor, which I consider as eminently anti-melodramatic in its focus on the body and on materialistic value. There is no emotional identification, unlike what we have in melodrama. We have unsympathetic characters that ensure critical distancing, and instead of compassion, a kind of self-defensive emotional anesthesia in the spectators. They refuse to let themselves be overly empathetic to the plight of the characters. We also have an irreverently indecorous treatment of topics that are not usually treated comically: disability, suffering, death. It's a kind of like a comedy of tragedy. We have no spiritualization, no moral idealization, but a kind of a social Darwinist world with the survival of the fittest. We have a preference from long and medium shots, unlike the close-ups of melodrama. And we tend to have an eminently unsympathetic soundtrack, a parodic soundtrack that also disinvites emotional identification. And I try to analyze in my article how this kind of humor is especially emergent in context of rapid social changes and relativization of values and institutions, when we have on the one hand the survival of anachronic authoritarian structures, but especially in the case of Spain in the late 1950s and early 1960s, economic modernization and liberalization. Also, there is a skeptical sensation in the creators of the movies of a perennial regime that has ample recognition that cannot be changed. The last movie I deal with is El Verdugo, The Executioner, from 1963, that managed to raise a lot of critique, not only nationally, but also internationally, because it was considered a satire against not only death, but death penalty. The movie appeared in the context of public execution, state execution of some anarchists and the communists by Franco's regime. So it was taken as a kind of derision of that. From the leftist side, it was also considered derisive on the right side. So it was overall considered extremely offensive. this movie basically shows how, in order to preserve their advanced spot for a state subsidized apartment, the son-in-law has to become an executioner like his father-in-law, because once the father-in-law retires, they lose their place in line for a state subsidized apartment. So the son-in-law is forced to continue the tradition of becoming an estate executioner, hoping that he will never actually have to act upon it, but will just be theoretically an executioner. Unlike melodrama, there is no initial nor final space of innocence. It starts in a prison and it ends in an execution. And it has to do a lot with how the individual can be made, gradually be made to become eternally servile to the totalitarian state who has biopolitical power and monopoly of violence. Here as well, I mentioned before, we have a subversive political humor, but also reactionary sexist take on gender roles. And one of the problematic, so to speak, issues of this comedy is that a lot of critics were against was what could be called an ethics of sympathy, but not a melodramatic one, but an undermining ethic of sympathy that is morally problematic, because the executioner's figure, okay, for some reason, the executioner figure looks like an endearing grandfather. You have it on the left. It does not look like one would expect to be a state executioner, especially in a totalitarian state. But this was taken to be as a pun at Franco's figure, who was nicknamed the executioner abroad, and who in the 60s changed his public image. He no longer appeared in military clothes, but as you see, a grandfather that enjoyed his domestic role. And one, probably the scenes without any kind of comic relief, and I was mentioning before the lack of close-ups, the lack of melodramatic close-ups. We have here a high-angle shot of how the young son-in-law is dragged towards the place of the execution because he refuses to perform his role. So we have an image where even the man to be executed actually comforts him and tells him that he needs to do his job. So this is one of probably the darkest parts of the movie, that because it's very difficult it's very difficult to see with through comic lenses, and it is also based on a real event, a lawyer that witnessed how the executioner refused to perform an execution and was eventually forced and dragged to the place of the execution. I don't want to. I'm probably late, so I don't want to go too much further. I just wanted to say that I think the main role of comedy, of such comedies in at that point of Franco's dictatorship with national and international recognition and stabilization, was not so much in the content of everyday living. People would not just change overnight just because they were watching a comedy, but in the frame and in the perspective that content was interpreted. So I see the role of comedy and of humor more as a role of moral and cultural attrition. So in kind of like a long-term war of attrition on the propaganda values of the state.
Thank you. Thank you so much, Diana, for this really interesting talk about these three quite different and really thought-provoking case studies. And yeah, we have a few minutes for questions. Nicole, I think.
Oh, yes. Thanks so much for this talk. And I'm struck by how all three of these presentations are so timely despite covering historical sources. And so I'm wondering, I'm thinking about how the antagonism towards law or within law works within the materials you're looking at. So for example, I'm wondering whether the ire about the state and the precarity and financial incapability of these young people is more directed towards state policies and legislation or towards the preceding generation. Because I see in a lot of the discourse nowadays about rent being too high and housing being unaffordable. On one hand, there's that okay boomer kind of aggressive humor that goes on, but there's also this antipathy towards state policies, and they don't really seem to be twinned as much as I would expect them to. So I'm wondering what your thoughts on that are. Thanks.
Thank you. Yes, it's a very good question. And I think given the context of Spain and given the fact that before this period of economic boom, we had an autarkic period of extreme poverty, the so-called years of hunger. There was not much to idealize in the previous generation. But I think the critique here is more towards the gap between, on the one hand, the state propaganda, the invitation to consumers to own your own apartment. It's affordable, you can afford it, you can have it, but the actual reality is that either you cannot access it easily, or even if you can access it, it comes at a very steep moral price, and it can actually be in very shoddy conditions. So it's not at all what state propaganda promises. So I think definitely the critique here is more directed towards the existing laws, housing laws, incentives that were inefficient. There was a lot of corruption as well. But mostly I think it's against state propaganda. What it was shown to be the truth and what was not the truth at all. So in reality, the housing reality was very different from what they were promised.
Thank you.
Thank you very much. And I see a comment in the chat by Lenora. Mr. Blandings builds his dream house is a wonderful Cary Grant film about home ownership as the American dream, remade as The Money Pit. Bureaucracy, building permits, repairs, all almost destroy the marriage of the couple. Yeah, so it's a really interesting case for a comparative analysis, perhaps. Yeah.
Actually, in the first comedy, the couple at some point ventures as everything fails in their apartment, if their marriage will also fail as well, because it's intrinsically as shoddy as the apartment is.
Thank you. So we still have 2-3 minutes left. Please stop me if I'm going over time, but for the time being, I will give the floor to Elisa for a question, and then I think Melissa is also in the waiting list.
Thank you very much. Thank you, Diana, for your paper. I have seen some of Luis Garcia Berlanga's movies, but not the one you mentioned. But I know that his movies, they changed in nature a lot, like after Franco's death. So I know that there was some sort of censorship going on. And I wanted to ask you, when did it take place? So was it at the moment when they wrote the script? Was the script did it have to be read by the censors, or was it after the production of the movie that the censor decided if it can be shown or not?
Yes, well, it was, I would say, both. There was a compulsory presentation of the script to the censors before the movie was even approved to start shooting. And then once the official product was done, there was another screening which deemed its ranking. There were a lot of different categories, and depending on that ranking, they would get or not their money back through state subsidies from the government. So it was a way of potential financial punishment for movies that went against the regime. Let's just say that Berlanga's movie was only shown in theaters for 2 weeks because it was deemed too offensive, and it did not get any reimbursement for its for the movie costs. Which was the lowest possible punishment that one could get. And also there was a lot of criticism. Apparently even Franco himself complained about the movie and said in a cabinet meeting that the director is worse than a communist, is a bad Spaniard. And then the Spanish ambassador in Rome, because it showed at the Venice Film Festival for the first time, said that this is an incredible libel against the whole society. Everything is rotten here. Nothing is saved. And so it was a very polemic movie.
Thank you. So it's basically 1:30 here. Do we have time for one extra time question from Elisa, maybe? I saw that you raised your hand, Elisa. I don't know if you...
Sure, yeah, I withdrew it just because I noticed the time. I was just going
Right.
to, I'll just throw it out there, food for thought. Curious if you had ideas about this inconsistency between the more radical, subversive political and economic critique and the more conservative, reactionary, as you put it, treatment of gender roles and sexual relations.
There are many potential explanations and very complex potential explanation, but I would just briefly say that the end of the 50s and the beginning of the 60s was also the time when we have a rise of, a much greater incorporation of the women in the workforce, in working outside the home, whereas we still have a very anachronistic legislation in place that basically lasted until the end of Franco's regime in 1975. Married women had to ask permission from their husbands in order to work outside the home. And of course, that put the men in a very awkward situation because they were supposed to be the breadwinners of the family, not the women. In any case, this rapid incorporation of the women in the workforce did trigger a lot of panicked reaction, even among the leftist intelligentsia of the time. And we see this very widespread, unfortunately, even in the more oppositional magazines, humor magazines of the time, not only in film comedies, that couple political critique with a very sexist take on women. And many times, and especially in dark comedies, they are made to be the main responsible for the main male protagonist's downfall and gradual moral disintegration.
Okay, thank you.
So that was wonderfully timed, and it just remains for me to say thanks to all of the speakers for an extraordinary and wide-ranging discussion. Thanks to Alberto for helping to organize it. Thanks to all of you for coming. And a quick reminder that we have another one coming up in a month on Monica Huerta's new book out from NYU, The Unintended. So I hope everyone who's interested in that gets a chance to come then. Thanks to all, and hope to see you soon.